My name is Vicky Kingston. For those that don't know me, I am the Managing Director of Juice Recruitment. I'm hoping you all know Juice Recruitment, but we are a commercial agency that cover the whole of the Southwest and can support any of your recruitment needs. And this morning, we're delighted to be on our third HR Hub with RWK Goodman, discussing discrimination case law. I know we've got quite a few cases to go through, and I've been a little bit late getting onto the forum this morning, so my apologies for the delay, but I will pass you over to Rich and Tim, who will no doubt different cases to discuss today. Obviously, there's a questions section at the bottom, and we've got our chat bot. So if you do have any questions or you want to stay on afterwards and have a discussion with us, please do. We are here to help. I will pass you over to Rich and Tim.
Thanks a lot, Vicky. Morning, everybody. Thanks very much for coming today. Yeah, the topic of today's conversation is discrimination in the workplace. As ever, there's a lot of case law around. Bit of housekeeping before I start. Just to say that, as Vicky said, we will be recording this session. You probably heard the Zoom automated voice. We're recording it from this point right up until the beginning of the Q&A, just so we can then circulate the talk around to people afterwards. So your colleagues who couldn't make it, who registered, who couldn't make it, can see the talk. So do please interact. You can either, like Vicky said, stick your finger up, ask a question. You can put something in the chat, or you can come off mute and you can ask us questions as you go. Rich and I are very happy to answer those questions. We would like to encourage interactivity because there's a lot about discrimination that needs discussing, basically. Some of these cases aren't straightforward. So yeah, please do raise questions as we go along, and if you want to ask something during the talk, please do. If we could all go on mute now, that would be amazing. And I'm going to pass you over to Rich, who's going to talk to us about the first of 4 discrimination cases we're going to be looking at today. And then after we've done those 4 cases, I'm going to be updating you on a couple of bits of other law that I think you need to know about in a little bit of detail. So, okay, over to Rich to talk about the first case today. Thanks, Rich.
Thanks, Tim. Morning, everyone. So, yeah, the first case I'm going to talk about raises a question: how did the height of electricity meters in Bulgaria in 2014 lead to British Airways losing an indirect discrimination case in 2022-2023? I'm not expecting everybody to chip in on the chat and answer that question, by the way. So the first thing we just need to look at is indirect discrimination. I'm just going to spend 1 minute on the concept of indirect discrimination, and then we'll look at the case and what it means for employers. So indirect discrimination, I'm sure we all know that applies when an employer implements a policy that is neutral, basically it applies to everybody. But the impact of that policy is that it puts a certain group of people compared to others. So to give you an example, a female employee comes back from maternity leave and wants to come back part-time from what was a full-time role, and an employer says, no, the job is full-time, you can't come back part-time. On the face of it, it's indirectly discriminatory on the grounds of sex, because it's an accepted principle. So can everybody just mute? Is it possible for everybody just to make sure they're on mute? Because I'm just getting a bit of feedback. Yeah, so a female employee wants to come back part-time from maternity leave. The employer says, no, it's a full-time role. And that, on the face of it, is indirectly discriminatory because tribunals will accept that women have the greater responsibility for childcare compared to men. So that's an accepted principle still in the employment tribunals. And so on the face of it, saying that a role has to be done full-time is indirectly discriminatory. That doesn't mean that an employee will succeed with a claim, because the employer then has to be able to justify why the role has to be done full-time. But in principle, that means then that the female employee can bring a claim for indirect sex discrimination. Now, in the past, if a man had said, we just had a baby, I would like to work part-time in connection with childcare responsibilities, that wouldn't have been indirect sex discrimination because men are not at the same disadvantage compared to women, according to the tribunals. So a man couldn't bring the same claim as a female employee in that type of scenario. So that's indirect discrimination. So then 10 years ago now, the electricity company in Bulgaria decided that because some of the electricity meters were being tampered with in that region, they would move them all up to a height where people couldn't actually access their electricity meters. So it became impossible for people to actually read their own meters, which seems slightly odd. But they did it because they were being tampered with and vandalized. Now, a group of people within that community were predominantly of a Roma ethnic background. And they brought a claim for indirect race discrimination, saying that you've done this in our community, that puts the Roma community at a disadvantage because most of us are from a Roma background. So that's a fairly standard indirect discrimination argument. But then somebody else in that community who wasn't Roma also said, well, hang on a minute, people from the Roma community can bring a claim saying that they've been discriminated against. Why can't I bring the same claim? Because I can't access my electricity meter either. And those people who also brought claims who weren't Roma, who didn't share that protected characteristic, succeeded with their claims because the European court said, well, you're closely associated or linked with that community, and therefore you should be entitled to bring a claim in the same way as people in the Roma group. So that was what that case was about 10 years ago. Not a lot happened really in English law until we had the British Airways case. What British Airways did, as one of the many cases they tend to be involved in the employment tribunals, is as a result of COVID, they restructured their sort of roster at Heathrow, and so cabin crew had to go through a process of having a different schedule for their work. There were about 50 odd people who were affected by that, who were based at Heathrow, and they faced a couple of indirect discrimination claims, British Airways, as a result of this new schedule. Predominantly two things. First of all, there was a group of staff who lived outside of the UK, who said, when you bring this new schedule in, that's going to put people who live outside the UK at a disadvantage because we have to commute to the UK to then be able to do our work from Heathrow. And the fact that we are living outside of the UK means that we're at a disadvantage. And most of the people who lived outside the UK and worked for BA were non-British. So what that group of people said was, well, this new schedule indirectly discriminates against non-British nationals because we live outside the UK and it puts us at a disadvantage compared to those people who live in the UK who are predominantly British. So that was one claim. And the other claim was from women who had childcare responsibilities from within that group of cabin crew who said the new schedule puts women at a disadvantage because it impacts our ability to provide childcare, and therefore it's indirectly discriminatory against women. So two claims. Those are fairly standard sort of indirect discrimination arguments. But what also happened in the BA case was that there was a British national who lived outside the UK in France, and he had to commute to the UK. And he said, well, if everybody else who's living outside the UK is able to bring an indirect discrimination claim, I should be able to bring one too, because I'm in exactly the same position as those people. I just happen to be British. So that person said I should be able to then piggyback effectively onto that indirect discrimination claim, even though I'm British. And also there was a male employee who said, well, I have childcare responsibilities. And so I'm actually in the same position as the women who are being put at a disadvantage because of this new rota. So I should also be able to bring a claim, even though on the face of it, I don't have the protected characteristic of being a woman. I'm in the same position. I'm at the same disadvantage. So why shouldn't I be able to bring the same claim? And the tribunals agreed and accepted that the British national who lived in France and the male employee who had childcare responsibilities should also be able to bring indirect discrimination claims. And it tends to be referred to as indirect discrimination by association, because usually the individual, the claimant in a tribunal case, has to have the protected characteristic that is subject to the disadvantage, whether that's being female or non-British. But the tribunal said, well, no, that extends then beyond that protection. So even if you don't have the protected characteristic of being a woman or being non-British, if you are at the same disadvantage, then you can also bring a claim. So this case was going through the tribunals for a while, and the Equality Act actually didn't really provide any protection for these individuals. But the tribunal said, we have to interpret the law in line with European case law, and therefore you are protected. So that was the situation up until the end of last year. What happened in January from this year is the Equality Act was amended to make sure clearly that people in that situation are also protected from indirect discrimination. So a really good example now would be if you have a male employee who says, I want to work flexibly in connection with childcare or other caring responsibilities, for example, doesn't have to be childcare. I would like to work flexibly. If the employer says, no, we're not going to allow you to work flexibly, you need to still come into the office or work full time or whatever it may be, that male employee may well be able to then pursue an indirect discrimination argument in the same way as a female employee has always been able to do. So for a long time, in that type of scenario, we would have said, well, you don't need to worry about an indirect discrimination claim from a male employee because they can't pursue the claim. They're not female. That has changed as a result of the BA case and then the change to the Equality Act that took place in January this year. So where does that leave you? What do you need to be aware of and think about? Well, first of all, the example I've already given around getting requests for flexible work, the potential to be challenged based on discrimination has now expanded as a result of the legislation change. But also, you need to think about other scenarios where indirect discrimination issues can sometimes arise. So, for example, if you have a policy or a rota or a requirement that people have to be in the office a certain amount of time, whatever the requirement may be that applies to everybody, if, for example, that puts a certain group of people at a disadvantage, so you might have a schedule that puts disabled employees at a potential disadvantage, you potentially face the risk of indirect discrimination arguments from disabled employees, but now you also potentially face the risk of indirect discrimination arguments from other employees who may also be disadvantaged by the schedule or whatever the policy is that the company implements. So, yeah, talking about indirect discrimination is never the sort of the easiest or the perhaps in some ways the most fun thing to do. But hopefully that gives you an idea of how indirect discrimination operates, how it operated up to a certain point in time, end of last year, and what you now have to bear in mind when some of these sorts of issues and challenges come up. You just need to address your mind more to, if we're introducing a new policy or we're changing something, who could this affect? Not necessarily just certain groups, but it goes beyond that now because of the Equality Act change. So unless we've got any questions in the chat at the moment, I will hand back to Tim to talk through the next case.
Thanks, Rich. Okay, the next case is the case of Turner Robinson and others versus Chief Constable of Thames Valley Police. The police do seem to get themselves into a lot of discrimination hot water. They always seem to be appearing in the tribunal or the employment tribunal. This is a reminder about the use of positive discrimination in the workplace and how it can go badly wrong if you do use it. Now, as a general reminder, what we should be doing is we should be making sure that those people with protected characteristics are basically treated no less favourably than the other people in the workplace that don't have those characteristics. But the one exception to that, where you can effectively promote somebody with a protected characteristic over another person, is positive discrimination. Now, it does come up once in a while. We do have clients that ask us about it, and we always say to them, yes, it's there to be used as part of the Equality Act, this right to positively discriminate. But you need to tread reasonably carefully, or you can get into hot water. So this is a case of the police force, Thames Valley, trying to implement positive discrimination in a in a recruitment process. So there are two types of positive discrimination. There's the general positive discrimination under Section 158 of the Equality Act. And there's also positive action in recruitment and training under Section 159 of the Equality Act. Now, this is a Section 159 recruitment and training positive action case. So basically, the positive action provisions will apply or can apply where an employer reasonably thinks that either, number one, somebody who has a protected characteristic suffers a disadvantage connected to that characteristic, or number two, participation in an activity by staff who have a protected characteristic is disproportionately low. Okay, so this is, as I say, one of the rare occasions where we can effectively promote people with a protected characteristic above everybody else if one of those two scenarios apply. To give you a general example, and this is Equality and Human Rights Commission example in their guidance note, if a company finds that from its research and its data that people over the age of 60 are struggling to engage in IT, for example, because age may be a barrier to them getting to grips with IT, as the data supports that, it may be permissible to give those older workers, the over 60s, specific IT training. And if it was proportionate, I'll come on to that in a minute, if it was proportionate means of boosting the over 60s access to IT, making them more familiar with IT, you would have good grounds upon which to do that. You shouldn't have a claim from the people who are lower than 60 when it comes to an age discrimination claim. So this case was a recruitment case for Section 159. In a nutshell, the police force, Thames Valley Police Force, wanted to fast-track ethnic minorities from sergeant to inspector. Okay, they took the view that ethnic minorities were underrepresented in the inspector region of their police force. Now, what they did was they automatically gave one ethnic minority sergeant the position of inspector. Now, three white officers, three white sergeants said, hang on, this isn't right, this is unfair. So they brought claims of direct discrimination, obviously not against the sergeant who was promoted, he hadn't done anything wrong, but against the police force. So the facts of the case are that the police force didn't actually hold any form of competitive interview. They automatically slotted the minority ethnic candidate into the role of inspector. So it went to the tribunal, and the tribunal found that this was a case of unlawful discrimination. Why did they think that? Well, they look back at what the Equality Act says, and it reminds us that we can only do positive discrimination if all things in relation to the recruitment are otherwise equal other than the protected characteristic. The Equality Act says, is there a need to overcome a disadvantage if all other things are equal? And it says, okay, is what is planned, in this case, the promotion of the ethnic minority to the position of inspector, is that a proportionate means of achieving a legitimate aim? And we're really familiar with this term proportionate, and it comes up a lot when we're looking at discrimination. So the tribunal looked at the facts and they said, firstly, this went beyond mere encouragement into the realms of positive discrimination. And they said it wasn't a proportionate means of achieving a legitimate aim. Now, why did the tribunal come to that point of view? Well, it said, looking at the CV of the minority ethnic candidate who they put into the role of inspector, they didn't actually suffer any disadvantage. They were equally well suitably qualified for the role, and therefore there was no effectively there was no position where they were at a disadvantage compared to the others. And what the police force hadn't done is they hadn't done a balancing exercise. They hadn't looked at whether the discrimination against the claimants, the 3 white officers, was outweighed by the advantage that was put on the minority ethnic sergeant. They were all at the same level. They all had the same qualifications. They all had the same background. And therefore, there wasn't any need to actually propel the ethnic minority sergeant into the inspector role. The ethnic minority candidate would have done just as well as everybody else on their own without the positive discrimination. And the tribunal took the view that the seriousness of their situation was not enough to justify the positive discrimination. So what the police force failed to do is it failed to go back to the original points, and it failed to look at whether there was actually a real disadvantage connected to the ethnic minority sergeant when it came to whether or not he would be disadvantaged in the application process because of his characteristic, which was his race. And the tribunal found that there wasn't any disadvantage. As I said, he was just as well qualified to sit in an interview, a competitive interview against his 3 male colleagues. And on that basis, he could just have done just as well as the other 2. So they failed to consider that proportionality. Is there anything that we need to do to help this underrepresented ethnic minority candidate get to a level playing field? And the tribunal said, well, there wasn't any unequalness, if you see what I mean. The big problem with this was that the police force didn't actually go through any sort of interview process with the 3 white sergeants. They simply told them, you're not going to be considered. We are putting this person into the role because of our equal opportunities policies that says we can positively discriminate. What they should have done is they certainly should have considered that proportionality, and they should have then made a decision at the end of the interview process with all 4 candidates, taking a view as to whether positive discrimination was appropriate or not, and they failed to do that. They excluded the white candidates. What the Employment Tribunal also said was that there wasn't any equality impact assessment done either. Now, any of you who have been involved in tricky discrimination decision-making processes will be familiar with equality impact assessments. The Equality and Human Rights Commission strongly suggests that they're carried out in instances where you need to make a decision that could otherwise be discrimination. And an equality impact assessment is effectively a business sitting down and putting its thoughts into a document to say, okay, this is what we want to achieve. This is what we're going to do in this particular situation. Is what we're doing proportionate? Is there any way of reducing the discriminatory impact on any persons involved in this, in this situation? Should we be doing anything differently? Should we change our process? And basically, how should we minimise the impact against, in this case, either the 3 white applicants or the applicant of the ethnic minority background. They didn't do any form of equality impact assessment when they implemented this policy, and the tribunal were pretty critical of them in that respect. Tribunal also found out there was pretty little diversity, equality and inclusion training in the workforce. So the people that made the decision to put in place positive discrimination didn't really understand the background of DE&I, and the tribunal were quite critical of the police force. In a nutshell, the police force was so focused on making the scheme work that they forgot to look at the justification argument behind why they were doing it, and seeing whether there was anything that could be changed to make it less discriminatory to the 3 white applicants. As I said, we do get clients who do ask us for advice on positive action, but I think what this case emphasises that it is a right that we can use in our workplace, but there are some quite strict limits as to how we can use it. And if we're ever thinking about using positive action in relation to discrimination in the workplace, we need to think really long and hard about why we're implementing it. Are we doing it for the right reasons? And can we make it better for any parties who may think that by the implementation of positive action, they themselves, in this case the white officers, they themselves are being discriminated against? Okay, so that's Turner Robinson and others versus Chief Constable of Thames Valley. I am going to hand you back now to Rich, who's going to talk about another discrimination case.
Thanks, Tim. Well, all I can say is it's no wonder the police end up in the tribunal so often, is it? Based on what you just said there. Moving away from the police and BA, who tend to spend a lot of time in the tribunals, there was a case, a very recent case involving, it is a publicly owned employer, the Royal Mint, and it was a case called the Royal Mint and Sarah Bradley. It's a disability discrimination case. What I would say before I talk through the facts and then what the outcome was, is it's an employment tribunal decision. Why is that important? Many of you will know that, you know, the process we have if someone wants to bring a claim is to go to an employment tribunal. If a decision is made that someone disagrees with, and if there's a legal basis to do so, you can appeal, and then you appeal to the Employment Appeal Tribunal, and then above that the Court of Appeal, and then above that the Supreme Court. Any decision of an employment tribunal, so the lowest level of tribunal, is not binding on any other tribunal. So a tribunal is only bound by the decisions of higher courts, like the Employment Appeal Tribunal, the Court of Appeal, etc. So this case was an employment tribunal case. The reason I say this is I mean, I have to say I had a lot of sympathy for the Royal Mint in relation to the outcome of this case. And I don't necessarily think that another tribunal would have made exactly the same decision. So that's a bit of a kind of just a heads up that, you know, every employment tribunal decision that happens doesn't automatically mean that they get it right. What it does also mean, though, is that litigation is a bit of a lottery. And so you can't always predict with complete certainty what the outcome of any case is, certainly let alone a discrimination case. So what happened in this case, Miss Bradley had worked for the Royal Mint for a long time. So 2009 she joined, she was in HR, she worked her way up over 13 years, became director of HR, and reported directly into the CEO. She suffered from anxiety and depression since 2013, and the employer was aware of that and aware that she took medication for that. She also received a diagnosis of ADHD in 2022, which she also made the employer aware of. Now, the relationship and Miss Bradley's behaviour from time to time, in terms of her interaction with colleagues, is probably best described as up and down. So there were periods of time when there were some challenges and some problems, probably linked to the way she reacted to things and her behaviour. But that didn't ultimately mean that relationship came to an end. It continued, but the extent of what I mean by ups and downs is on 2 occasions. So in 2019 and 2021, Miss Bradley attempted to resign and end her employment, But each time the CEO said, I'm not going to accept your resignation because I don't think you are thinking straight at that particular point in time. So the CEO assessed each time Miss Bradley tried to resign, and said, I don't think this is actually what you really want to do. It doesn't seem to me that you're in the right frame of mind at the moment to be making those decisions. And ultimately the issues then that had led Miss Bradley to try and resign were resolved, and she carried on working for the Royal Mint. So after Miss Bradley was then diagnosed with ADHD in 2022, she went on to some ADHD medication, and she stopped at that point taking her antidepressant medication. She then had a clash. So after that, she then had a bit of a clash with the executive team, which had happened in the past. The issues were kind of discussed and they calmed down a little bit. And then not long after that, Miss Bradley said she wanted to resign, and she handed her resignation into the CEO. And the CEO on this occasion asked if Miss Bradley was okay, and she said she was. And it appeared to the CEO that this was different from the previous times she had resigned. It didn't seem to be done in a sort of a heat of the moment type resignation. This seemed to be a pre-planned, thought out decision. They even discussed the reasons why she was resigning, where she said it included salary. She didn't think she was paid enough, even though she had actually had some fairly significant pay rises in the recent past. She wanted to look for more lucrative interim roles in London. She felt the job had become a bit stale and repetitive, so that's why she'd made the decision to resign. After she resigned, that was communicated internally. They started a search for her replacement, and she was working her notice, I should say, so she didn't leave straight away. They started the search for her replacement. Miss Bradley started to help the company with that search for her replacement. They even told third parties. So the Royal Mint is owned by the government, and they told the Treasury, for example, that Miss Bradley was leaving. So it was obviously an open knowledge that everybody knew that was what was happening. About 3 weeks later, Miss Bradley said to the CEO, I'd like to rescind my resignation. And the CEO thought about it and said, no, I'm not going to agree to your request to rescind your resignation. Miss Bradley said, well, I don't think I was thinking straight at the time. And the CEO took the view, I don't agree. Based on all the circumstances, how you appeared at the time, the fact that we're now the reasons you gave, we're now 3 weeks on, we've communicated it to everybody. First of all, I think you did resign sort of, voluntarily, as it were, and you knew what you were doing. And also, we've now moved on. 3 weeks now down the line, we've moved on, and it would be too disruptive from an operational point of view to say, right, we'll stop the recruitment process, we'll rescind your resignation, we'll tell everybody that you're not actually leaving. And the employer, I think, was also slightly concerned that then they might find that a few weeks later they then had another resignation on the table. So they felt that was too disruptive. So Miss Bradley then appealed, and they rejected the appeal. And Miss Bradley brought claims then to the Employment Tribunal. She didn't succeed with any of her claims except for one. And that one claim was a claim under Section 15 of the Equality Act, a claim for unfavourable treatment arising out of someone's disability. So Miss Bradley's argument was, you treated me unfairly by not allowing me to rescind my resignation. And on the face of it, even though people might think there was a good reason for not agreeing, nonetheless, that was in a sense treating her unfavourably because she'd made a request and they said no. So that was unfavourable treatment. She said, the reason for this all came out of my disability. I'd stopped taking my antidepressant medication. I'd gone on to my ADHD medication. That had an impact on how I was thinking and functioning at the time. And therefore, my resignation, and therefore the unfavourable treatment that you've subjected me to, is directly linked. So you saying no to my request to rescind my resignation is a direct link to my disability, because that's why I'm in this situation. So now if an employee can show that they've been treated unfavourably, connected to a disability, it then shifts to the employer to justify why they've treated the employee in that way. So in this case, the Royal Mint then had to justify why they didn't agree to rescind the resignation. And the reason why the Royal Mint failed with their defence, and the reason why the tribunal upheld Miss Bradley's discrimination claim, was fundamentally because the Royal Mint didn't go and get any medical evidence at the time to decide whether or not Miss Bradley's health issues had impacted on her decision to resign at the time. So what the tribunal said the Royal Mint should have done is they should have stopped, they should have, before saying no to the rescinding of the resignation, they should have gone to get some medical evidence, and then they could have considered that medical evidence, and then they could have made a fully informed decision as to whether or not they should allow Miss Bradley to rescind the resignation. So to me, it seems, on the facts, ignore the law for a minute, on the facts, it seems kind of quite a harsh decision on the Royal Mint, who did seem to have genuine and valid reasons for rejecting Miss Bradley's request. What the tribunal said was, but if you had gone to occupational health, for example, or possibly even a psychiatrist, and if you'd got a report, you could then at least have considered that as part of your decision-making process. The Royal Mint may still have come to the same conclusion. They might still have decided that based on the medical evidence at the time, they were still going to reject her request to rescind the resignation. But what the tribunal said was, by not going and getting a medical report and basing your decision on proper, full evidence, you have therefore failed to sort of justify your decision. So the Royal Mint failed in that case. As I say, it is a tribunal decision. I'm not entirely sure that all tribunals would have come to the same conclusion, and it's possible, I don't know, it's possible that this case might even be appealed itself. So sometimes these things can change. But it is a real lesson, I think, for employers in relation to these Section 15 claims that are getting more and more common in tribunals. So if an employee has a disability, and if they believe any sort of treatment that they have been subjected to by the employer is in some way linked to their disability, they can argue that that's unfavourable treatment, and the employer then needs to be able to justify why they've treated the employee in that way. And there's lots of different scenarios where this can arise. The Equality and Human Rights Commission Code of Practice gives some examples of this type of situation. So an obvious one is that they give in the code is where an employee who's suffering from, who's got cancer, who is going through treatment for cancer, and then is feeling tired and, let's say, irritable, more so than they normally would be because they're going through this treatment, and then they react to someone in the workplace and they say something they wouldn't normally say, and they are then dismissed or disciplined by their employer because they've done this. That is a potential disability discrimination issue, because the reason they've been disciplined links back to their disability. So that's just one probably slightly more obvious example. This particular case here, the Bradley and Royal Mint case, wasn't such an obvious example, but it's just worth bearing in mind if you get situations where an employee, you know that they've got a disability, you know that it might be having an impact on them, and it might have impacted, for example, their behaviour or their performance. You need to be able to show that you've thought about that and you've properly investigated it, and you can therefore demonstrate that your decision is overall reasonable and proportionate, which isn't always the easiest thing to do. So yeah, don't think that the Royal Mint, we're always going to lose that case. Key point there was they didn't really quite get the process right before they made their decision. I will hand you back to Tim.
Thanks, Rich. Okay, so any of you who came across to our HR Hub in May of this year, I think it was, will have heard us talk about the case of Rachel Mead and Westminster City Council. She was a social worker who won £58,000 because of gender critical beliefs, which she posted on her Facebook page. We are starting to see more of these gender critical type cases coming through in the employment tribunal. So Rachel Mead was a case where her employer, Westminster City Council, and her governing body, the Social Work England, lost. And as I said, they had to pay £58,000. We've had another case much more recently, the case of Orwin and East Riding and Yorkshire Council. So again, this is a case which looked at the very hot topic of people raising gender critical beliefs in the workplace. Now, you may know this case as the press referring to it really as the X chromosome guy case. So Mr. Orwin was employed by East Riding of Yorkshire Council. The council put in place an email pronoun sign-off policy, which a lot of companies are doing or have done. Now, he had pretty strong gender critical views. He was pretty sure that sex is biologically immutable, i.e., if you're born a man, you can never be anything else but a man, and the same for a woman. You can't change your sex. So the council put this email sign-off pronoun policy in place, and it's fair to say he kicked off. He didn't like it. He made his views very, very clearly known. The council went through kind of informal discussions with him. They talked to him a lot about his sign-off, and then he took it a step further. He didn't like what the policy was. He didn't believe he should be made to, not express his view. So on one particular occasion, he changed his email sign-off to Mr. Orwin, underneath that X chromosome guy / adult human male. So quite rightly, East Riding of Yorkshire Council took him to a disciplinary. And interestingly, in that disciplinary, he said, "I'm not accepting this garbage." He was very, very specific and quite vitriolic in his views of gender critical belief. And he actually went as far as to say that he was deliberately putting in place provocative pronouns to make his point. So the disciplinary hearing went ahead, and the council said this is unacceptable. We have a very, very public facing personality to uphold and position to uphold. We're a prominent employer in the area. We must be seen to do the right thing. So they listened to what he had to say, including his garbage comment and his comment about I'm being deliberately provocative. And they came to the conclusion that he'd been given a lot of warnings. He'd failed to repeat that. And so they dismissed him for gross misconduct. So Mr. Orwin went to the Employment Tribunal. He brought claims of unfair dismissal. As you would, he brought claims of wrongful dismissal because he was dismissed without notice. And he also brought a discrimination claim based on gender reassignment. The tribunal looked at everything that had happened, and in a decision different to the Rachel Mead case, they said that his claim failed. None of his claims were upheld. He lost on all his claims. And the tribunal were pretty clear about how they're starting to interpret the manifestation of gender critical beliefs in the workplace. Now, in the Rachel Mead case that we talked about in May, what Rachel did wasn't particularly provocative. Wasn't really meant to shock anybody. It wasn't meant to disturb people and to really be detrimental and harm people's feelings. So she won £58,000. But here they took a very different view, and they looked at the motive behind why Mr. Orwin had done what he did. And in essence, they said, looking at all the evidence, he'd taken a very, quote, deliberate and provocative act to mock gender self-identification. So we've got a case here where somebody has manifested their gender critical beliefs, but they've done it in an objectionable way. They've done it with the sole intention of mocking other people. And that specifically came not only from his email sign-off, his pronouns, it was intended to cause people hurt, but also the evidence that had arisen throughout the consultation period about what he was doing, but also the disciplinary hearing. There was clear evidence that he was doing it to be deliberately provocative, and he wasn't simply just putting forward the manifestation of what he believed in. He'd overstepped the mark. He'd gone way too far. So his claims failed. When we look at the unfair dismissal part of his claim, it's quite clear to see that the council gave him plenty of warnings before they made it formal. They went through a proper disciplinary process with him. They gave him the right of appeal. But still he held the same views. And interestingly, the council chose exactly the right reason to dismiss him. He wasn't being dismissed because he held views. He was being dismissed because he clearly disobeyed what were considered reasonable management orders. So it shows us that it's very important to get your reason for termination right, as it can flow through to a tribunal, and you will then be expected to justify why you dismissed somebody and what your grounds were and why that was reasonable. I come back to this word proportionate again, because it's a discrimination case. The tribunal looked at whether the council were proportionate, because on the face of it, this is a dismissal of somebody who holds a protected characteristic, and that protected characteristic was that he didn't believe that, you know, sex could change. So in a nutshell, he may be protected by the gender critical reassignment part of the Equality Act. So the council had to do a balancing exercise. Okay, are we being too harsh against Mr. Orwin for the views he held? Or do we have another good reason why it is reasonable and proportionate to dismiss him for what he did? And the council came to the view that, yes, there was a good proportionality argument. There was good evidence to say that the council's policy was a genuine attempt to be inclusive. It was also a proportionate decision to dismiss Mr. Orwin because the council was in a very public-facing role. They had a very significant risk of reputational damage. So in this case, the tribunal said, we side with the council. What you are trying to achieve effectively trumps Mr. Orwin's views, given the way that he has conducted himself in this particular instance. So we've got two differing cases there, Mead and Orwin. We're starting to get a flavour of what tribunals are thinking, how they're going to view these types of cases, because we certainly haven't heard the last of gender reassignment discrimination cases. They will become more prevalent in the workplace, and there will be many more cases, but we are starting to get an idea of just what the tribunal are looking for when they hear these cases and they come to a decision. Okay, so that's the 4 discrimination cases I want to talk about today, or we're talking about today. I would just like to flag up, before we go to Q&A, a couple of things that have come up. Labour are going to drop this predictable working pattern law they were going to bring into place. Anybody who came to the last HR Hub on the Labour changes or plan changes to the workplace will have seen that Labour were going to make it law to get people who would work flexibly, 0 hours contracts type workers. They were going to give them the right to ask for a predictable working pattern. Now that, I think, could have caused a lot of problems, and I'd be interested to see how Labour implemented it. They've now dropped that, so they're not going to be implementing this predictable working pattern in contracts. Instead, what they say they're going to introduce is a new right to a contract that reflects the number of hours regularly worked. Now, your guess is as good as mine as to what exactly that is, how it's going to be implemented, Labour's 100 days, that magic 100 days, is up on the 6th of October. So I'm hoping in the next 2 or 3 weeks, we are going to see a lot more clarity from Labour about what exactly they're going to change about employment law. Equality and Human Rights Commission have been busy. They've issued some guidance on supporting disabled workers with hybrid working. That came out on the 5th of September. Anybody who's heard me talk before will hear me rave about the EHRC guidance notes. They're very good. They're very clear English, and they give lots of good examples. EHRC have named 6 organisations that failed to report their gender pay gap data for the last year, 23-24. So they're putting their money where their mouth is, and they are now naming and shaming people. And finally, for anybody who has clients who work in the hospitality sector, there's going to be a new tip bit of law coming into place on the 1st of October of this year. The Employment Allocation of Tips Act 2023. So that is going to put in place some pretty stringent tip obligations. There's going to be a new code of practice. So I suggest you read that if you have clients in the hospitality and the tip industry. Failing to pay tips will specifically be classed as wages under the Unlawful Deduction from Wages Act. People who think they have not been paid tips properly, and in a nutshell, all tips must now go to staff, management can't keep them. If you think you've been underpaid, you have 12 months from the date of when you think you've been underpaid to go to a tribunal. That's quite significant because it's 12 months as opposed to 3 for unfair dismissal. Compensation of up to £5,000, so again can be quite significant. And companies need to keep a record of tips that they've received and allocated for the previous 3 years. So if anybody has clients in the restaurant sector or any other sectors that has tips as an issue, do give your RWK Goodman contact a call, and we'll be happy to give you any advice on that if it would help. So that is the end of the talk today.